Be ready, 10 seconds to go. Start. The borrower, instead of complying with the said order, preferred appeal number 267 of 2005 before the DRAT, which admitted the appeal and passed the following interim order. Pending passing further orders, the appellant shall deposit a sum of rupees 7 lakhs directly to the first respondent bank. However, there shall be stay of implementation of the order in favor of the second and third respondent. It is apt to state here that the appeal was directed to be posted. The bank filed a reply before the DRAT highlighting the consistent default by the borrower. The auction purchaser, the third respondent herein, did not file an appeal before the DRAT but filed an application under Section 151 of the Code of Civil Procedure. The DRAT took up the application and observed that as the purchaser had already been impleaded as a party to the appeal, she would have the right to address the court and accordingly disposed of the application. As the factual narration would reveal, the appeal was adjourned from time to time and eventually the DRAT passed the following order. Counsel for the parties present. I have heard them at length. Counsel for the appellant is ready to pay the entire amount up to date minus the penal interest for which no provision was made in that context. The column of penalty portion was left blank and no amount was mentioned therein. Therefore, I am of the considered view that the appellant has not to pay the penal interest. The residue amount be paid to the bank within 45 days from today as agreed. The builder has already recovered the amount of rupees 7 lakhs from the bank. The amount will be paid by the appellant to the bank directly within 45 days as agreed. The appellant will also pay simple interest at the rate 9% from the date of payment to the builder till its realization within 45 days. As agreed by the auction purchaser, he is ready to accept rupees 5 lakhs as costs from the appellant and would not insist for auction sale and would surrender his rights in favor of the appellant. It was also agreed that the rupees 5 lakhs are to be deposited in the bank by the party concerned. The said amount be deposited with the registrar of this court within the period of 45 days, failing which the appeal shall stand dismissed on this deposit as well as other deposits stated above. The auction purchaser can withdraw this. Liberty is also given to the auction purchaser to file action against the bank for any omission committed by it. Liberty is given to the appellant as well as to the builder to get the registry executed in favor of the appellant within 2 months thereafter, that is, after the elapse of 45 days mentioned above. Stamp duty, etc., will be paid by the appellant. The bank is further directed to furnish the statement of accounts minus the penal clause within 10 days. The bank is further directed to return the amount deposited by the auction purchaser in the sum of rupees 25 lakhs along with the normal interest at the rate 9% per annum simple without prejudice to his right against the bank. The matter stand disposed of. Auction purchaser and the appellant are directed to sign this order. Aggrieved by the aforesaid order, the bank preferred writ petition and raised two contentions, namely 1. The DRAT had modified a reasonable and detailed order passed by DRT by this very unexpected and unreasonable order, and 2. That the DRAT erred in granting liberty to the third respondent to initiate any action against the bank for any omission. The High Court of the impugned order in the first paragraph dealt with the element of the claim of penal interest and opined that the grievance of the bank was baseless, thereafter adverting to the grant of 9% interest towards deposit made by the auction purchaser with the bank, observed that there was no error in the same as the money was lying with the bank. Thereafter, the writ court proceeded to observe as learned counsel for the auction purchaser points out that, in fact, this interest of 9% is really not full compensation but only part compensation, as liberty has been granted to the auction purchaser to pursue the remedy against the bank, as according to the auction purchaser this property was auctioned by the petitioner bank without even disclosing the factum of the case pending between the owner and the bank in the DRT. We see no reason to exercise our extraordinary writ jurisdiction under Article 226 of the Constitution of India. The learned senior counsel appearing for the appellant submitted that though two issues were raised, yet he would confine his relief to the second one only. Stop.